All right. Thank you so much for that kind invitation. I'm afraid that I actually, since I'm here to talk about ethics, I feel compelled to clarify some of the nice things that Bryce said about me. So I'm now on a different DC Bar committee, no longer the Rules Review Committee. Let's see what else. I was on the board of the Association of Professional Responsibility Lawyers, but I am no longer. So anyway, slight clarification there. All right. So let me tell you, first of all, that I welcome your questions and comments at any time during my presentation. You don't need to wait until I'm done to start participating. And I want to warn you that I will be asking for audience participation. I'm a law professor. You know the drill. So, okay. As Bryce said, much of my professional work has focused on government ethics and legal ethics. In about 2010 or so, I became interested in government contractor ethics, and particularly in light of the fact that the federal government, at least, engages in a really enormous amount of service contracts on the order of hundreds of billions of dollars per year. So I conducted a study for the Administrative Conference of the United States, a small sort of research agency within the executive branch. And my study was called the Ethics for an Outsourced Government. And I looked at how, if at all, government ethics principles applied to government contractor personnel who were conducting services on behalf of or for the federal government. Let me give you a hypothetical. I'm a law professor, so naturally I need to give you a hypothetical. And I'm going to ask you to explain how you think the law in your state would apply to this hypothetical. Okay, so let's suppose that the government needs to assess whether to extend a large and controversial contract, and the government asks one of its in-house experts, a government employee named Dennis Clear, to conduct that assessment. So Clear does the assessment of this contract and recommends that the government extend the contract. But it turns out that this government employee, Dennis Clear, owns stock in a company that is a subcontractor on that contract. And that subcontractor, and by implication Dennis Clear, the government employee, will benefit financially if the government does extend the contract. Okay. Is there any legal or ethical problem with what Dennis Clear has done, making this recommendation? In other words, is there any law that would prohibit, say in your state, a government employee, Dennis Clear, from performing an assessment of whether to extend this contract when he owns stock in a subcontractor and will financially benefit if the contract is extended? Okay, so now, this is the audience participation part. I'm looking for a show of hands, or I don't know if there's you want to grab a microphone?
There are 2 microphones, just FYI, so raise your hand and we will hand you a microphone.
And if no one volunteers, I'm not above calling on people.
Oh, you are a law professor. Right here.
We got a volunteer.
In Illinois, we look at both contractors and subcontractors. And there are certifications that are required because it's Illinois. And for those of you who don't know and know me, we have had some governors go to jail. So our ethics portion of our procurement code has very strict conflict of interest rules. So it would be barred in our state from doing that.
So just to clarify, in this part of the hypothetical, Dennis Clear is actually a government employee.
Yes.
Okay. And so, so when you talk about certifications, can you just clarify what are those, who makes the certifications and what do they say?
So the subcontractor has to disclose ownership and relationships.
Okay.
So that comes from the subcontractor. But then there is also a responsibility in our ethics section on what the government employees can do as well, and the relationships between the governmental employees, contractor, and subcontractor.
Okay, so Illinois regulates the ability of its own employees to participate in a procurement where the employee could financially benefit. And I say regulate, presumably Illinois prohibits that from happening. Okay, any other states have over here, perhaps, or so?
I'm Delaware, and we do have a public integrity chapter which covers various things, including ownership or participation on the vendor end from an employee.
Okay, so if Dennis Clear is in Delaware, a Delaware employee, this would be prohibited.
He'd get a Chapter 58 violation.
Okay, awesome. And over here?
Sorry. In Alaska, it depends. So there would definitely have to be analysis to see if there's any substantial impropriety and if the individual was, expected to gain, any sort of, whether or not it's a huge, benefit, if it's the same benefit that any other person could benefit. But he could ask his, ethics supervisor for an, opinion and then figure it out.
Terrific. Okay, so that's cool. Oh, wait, one more.
I have a comment myself.
Please.
Nick Hughes from NASPO. So as this is an extension of the contract, we're going to be looking at historically how long is the contract in place. That's something that I would want to dive into.
Mm-hmm.
If he has ownership or an interest in the company, I'm going to want to look at, go back and look at how far that's gone.
Whoa. Good. That's fantastic. And a really good point. And find out whether Clear was involved in the earlier award of the contract, for instance. Fair enough. Okay, so sounds like a bunch of different states regulate their own employees' financial conflicts, probably broadly, but certainly in the procurement space. And just FYI, on the federal level, there's a criminal statute, 18 U.S.C. 208, prohibiting government employees from participating personally and substantially in a matter that would affect their own financial interest. And as you alluded to, there are regulations that sort of modify application of this statute, and there are certain regulatory exceptions and so on. But in general, at the federal level, there's a criminal prohibition on personal conflicts of interest of government employees. So if Dennis Clear had been a federal employee and advised the federal government to extend a contract that would have financially benefited him, he could go to prison because of this personal conflict of interest. Now, here I want to acknowledge he could go to prison, and I need to acknowledge that federal prosecutors are loath to, or hesitant or rarely actually bring cases under this statute, but nonetheless, it does happen. And of course, in addition to this criminal statute on the federal level, the federal government has a whole ethics infrastructure set up to detect and prevent conflicts of interest. So many federal employees have to fill out financial disclosure forms, and then those forms are reviewed by government ethics officials to prevent conflicts from happening. Okay, fair enough. Now, let me change the hypothetical just a little bit. The government still needs to assess whether to extend this large and controversial contract, but this time, instead of assigning the task to one of its own employees, it contracts with an outside company to do that assessment. And that company has one of its employees, its president actually, his name is Dennis Blair, conduct the assessment. Now, Blair reviews the information, recommends that the government extend the contract. And it turns out that Dennis Blair, like my hypothetical Dennis Clear, own stock in that same company, which is a subcontractor on that government contract. And Dennis Blair, like Dennis Clear, will financially benefit if the government extends the contract. The only difference is that the individual working on the procurement question, in this case Dennis Blair, is an employee of a government contractor rather than an employee of the government itself. So, in this slightly changed situation, is there any legal or ethical problem with Dennis Blair, this employee of a government contractor, advising the government on this procurement? Or, put another way, if this happened in your state, is there any law that would prohibit an employee of a government contractor like Dennis Blair from performing an assessment of whether to extend this contract? All right.
In South Carolina, there is nothing in the procurement rules. So if it were captured by some criminal law I'm unfamiliar with, like breach of public trust, then I wouldn't know the answer. But in the procurement framework and in the government ethics rules, nothing would prohibit that.
Hear that? At least in South Carolina, as far as we know, complete absence of any kind of regulation of this kind of conflict of interest. Okay, but maybe that's not true in other states. Anybody else? Is there anybody who knows about standards in your state that would regulate this situation?
Not necessarily the standards, but it would breach our general terms and conditions. We have standards of care for vendors that they have to perform in our contracts, and that sounds like they would be violating those standards of care.
That's interesting. Can you tell me just a little bit more about those standards of care, what they say, and how they might apply here?
They have to exercise professional conduct in accordance with their industry. So just basic standards of care, acting in the best interest of the state as our agent. I would have to go through those contractual provisions, but again, it would be a contract issue if they didn't perform.
And do you happen, fair enough, and do you happen, this is what happens when you volunteer, is I like then, come back to you. I know, but just one more. It's okay, right? Do you know whether those sort of standard contract terms, standards of care have been applied in anything analogous to this kind of situation where there have been contractor employees who have had conflicts, what we would call conflicts of interest?
Not that I'm aware of.
Okay, so maybe there might be law about it that could be applied, but you're not aware of any actual application of it.
I'm not aware of any situation.
Fair enough. Anybody else? Yeah.
In California, it would be unlikely that that contract would exist because we have a civil service mandate. And so we would say that that can't be contracted out, that type of evaluation. I would think it would have been the same in the federal government, though, because here's why. Isn't it an inherently governmental function? No, apparently not.
Oh, sorry. Just to be clear, I'm not laughing at you when I say, I know it sounds like, but honestly, I am not laughing at you. I'm laughing in frustration, and you'd think that she was a ringer, like that I paid her to make that comment. Okay? So that's why I'm laughing. Please go ahead.
No, it's just I would think that evaluation would be an inherently governmental function that presumably a department would not contract out for. But I'm sure that it has happened. But in California, the civil service mandate is pretty strict. We're pretty harsh about that. And so if there is a state employee that could perform that function, we would probably not approve that personal services contract to have a contractor evaluate extending a contract.
That's fascinating. Okay, so I want to just take a moment to pause and underline two phrases that you used. I understand that some of the folks in this room are relatively new to the procurement world. And I don't come out of the procurement world either, but what I found were that two phrases that you used are really critical in this issue, to understand this issue of personal conflicts of interest of contractor personnel. or as I say, ethics for an outsourced government. And one of them is this idea of an inherently governmental function. Okay. Raise your hand if you know what that phrase means. So, inherently government function, or governmental function, the idea of that phrase, of that concept, is that there are some types of activities that the government simply has no business outsourcing to contractor personnel or to a contract, an outside company. So, for instance, judging, adjudicating would probably be considered an inherently governmental function. It's generally something that requires discretion, and involves the exercise of discretion and, in some cases, like the exercise of sovereign power, okay? Anyway, there are prohibitions on outsourcing inherently governmental functions. Apparently, those prohibitions in California are respected. And the reason I laughed when you talked about it is that in my view, as an observer, basically an outside observer, is that those, I would assert that those restrictions are not very well recognized or enforced by the federal government. So there are on the books prohibitions on outsourcing certain types of functions, including like the exercise of discretion in assessing whether or not to award a contract, right? That is an inherently governmental function. But what the government ends up doing is it awards contracts to assist itself in engaging in those inherently governmental functions, okay? Advisory contracts. In the other phrase I wanted to underscore was your use of the phrase personal services contract. Congress, for instance, has imposed certain restrictions on personal services contract. The idea being government agencies should hire government employees if they need personal services conducted. Because when you have a government employee engaging in whatever function, there are all sorts of protections that are, accompany that. If a government employee is involved, a government employee swears an oath to abide by the Constitution, for instance. Those restrictions don't apply to contractor personnel or to contractors who have personal service contracts. So there are limitations anyway on personal service contracts. Okay, so I guess what I want to say is that at the federal level, while we have a criminal statute prohibiting federal employees from participating in matters that can benefit themselves financially, this situation that I described, this variation on my hypothetical, he's actually a non-hypothetical, Dennis Blair, a retired admiral who was an employee of an outside organization rather than an employee of the government, retired admiral, and he evaluated whether the government should extend a controversial contract for the F-22 jet fighter, and he owned stock in an F-22 subcontractor. And at the time he did this, in 2006, and actually now, he was free to make a procurement recommendation in which he had a financial interest. Now, as I say, when this happened, actually happened in 2006, Blair didn't even have to tell the government about his personal interest in this conflict. So it remained secret until years later when a good government group discovered it when it was like combing through SEC filings and saw that he had a financial interest in this F-22 subcontractor. And Blair, God bless him, denied when he was later, asked about it by journalists that his financial interest in the subcontractor had any impact at all on his recommendation to the federal government that they extend the F-22 program. Okay, so at least on the federal level, someone like Dennis Blair at the time would not be reached by certainly the conflict of interest standard for government employees. All right, let me change the hypothetical in a different way. All right, so the government still needs to assess whether to extend this contract, and the government contracts with an outside company to conduct that assessment. But it turns out that that outside company had actually been a subcontractor on the original contract. So in conducting its assessment of whether to extend the contract, it will actually have to evaluate its own past work. Now, in this changed situation, is there any legal or ethical problem with the company advising the government on this procurement when that advice will basically require it to assess its own past performance? If this happened in your state, is there any law or regulation or otherwise, anything that would prohibit this company from performing an assessment of whether to extend the contract, thereby evaluating its own past work? Again, asking for volunteers.
You guys got to speak up, jump in, please. In South Carolina, until 2019, no, nothing on either your first or this one. Free reign.
There's someone up here.
We go? Okay. In Nevada, we have an administrative regulation regarding multi-step projects that if a vendor designs the project, they can't then bid on the resulting design, and that would apply here.
Awesome. So Nevada has a regulation?
Yeah, it's an administrative regulation.
Administrative regulation that would address this kind of conflict of interest. Anybody else? Any other states? So.
Coming over. Hold on, we got.
Oh, good. Good.
We're just stretching.
New York has something similar to what Nevada has. We call it downstream prohibition. There's a statute, similar concept, that if they design a system, they can't then bid on one of the later phases of that system.
Got it. Okay. Thank you. So particularly for those of you who are relatively new to the procurement world, this is what is, at least at the federal level, referred to as an organizational conflict of interest. So my first two examples, my hypothetical and then my example of Dennis Blair, are personal conflicts of interest of, first, a government employee, and then second, an employee of a government contractor. Okay, so personal conflicts of interest, or PCIs. All right. This is referred to as this hypothetical is referred to as an organizational conflict of interest, or OCI. The federal government began addressing organizational conflicts of interest like this back in the 1960s, and eventually adopted executive branch-wide regulations to limit them. And those regulatory restrictions and standards to address organizational conflicts of interest, or OCIs, have been on the books for decades. By contrast, the federal government has imposed restrictions on the personal conflicts of interest of contractor personnel only relatively recently and only relatively narrowly in scope. So I want to focus on this question of personal conflicts of interest. So, what do I mean by a personal conflict of interest? They can arise in a number of different ways, but for today's discussion, I want to focus on a conflict of interest that arises when an employee of a contractor can exercise discretion in a way that could benefit herself or another person or organization with whom she's associated, her sister. Okay, so the Dennis Blair situation, my second example, falls into that category. Dennis Blair was able to exercise discretion in making a recommendation to the government in a way that could benefit him personally and benefit an organization that he's associated with, this company that he owns stock in. Okay, and this issue of personal conflicts of interest arises in a number of different settings, not limited to the procurement setting, but it certainly it can arise in the procurement setting, in part because the government has outsourced so much of its has engaged in so much outsourcing of its work in the in the service contracting world that it has really very limited capacity. And one of the places where this arises is in information technology contracts. The government is enormously reliant on outside contractors in dealing with information technology. And I've been told that for many governments, they are basically unable, they do not have the capacity to buy complex information technology systems without first hiring outsiders, and by hiring, what I mean is contracting with, without first contracting with outsiders to set up requirements, to evaluate bids, to monitor performance. So I guess I want to underline that the regulation of personal conflicts of interest of government contractor personnel differ substantially from the ethics, to the degree they exist at all. They differ substantially from the ethics standards that apply to government employees, like my Dennis Clear example. And they differ both in terms of the substantive standards that apply, but also in terms of procedural mechanisms. And so by substantive standard, I'm referring to something like the federal financial, criminal statute that imposes this financial conflict of interest standard on executive branch employees, 18 U.S.C. 208, that you can't participate personally and substantially in a matter in which you have a financial interest. But a second way that the sort of regulatory regime, such as it exists at all, is different, is that, as I alluded to, in addition to having those substantive standards, the federal government has a whole infrastructure for implementing those substantive standards. So, a lot of government employees have to file these financial disclosure statements on an annual basis, and then there are other government employees, ethics officials, who review those statements and give direction on whether or not certain stocks have to be sold, or whether a person's work for the government has to be limited in light of the stock or other financial interests. And as I say, this issue of personal conflicts of interest arises acutely in this context of service contracting. The government has, over a number of decades, say about 4 decades or so, radically increased the amount of outsourcing, and the areas of particular concern from an ethics point of view, it seems to me, are contracts, advisory and assistance contracts, staff augmentation contracts. And in fact, I have heard about an an information technology director for a government agency being hired off a staff augmentation contract. So the head of IT for a government agency isn't even a government employee. They're just contractor personnel. And so whatever ethics standards that we were talking about regarding that first hypothetical that restrict conflicts of interest will likely have no application to the head, the IT director, because the IT director ain't a government employee. They're contractor personnel. So, yeah, we have hollowed out agencies and a lack of capacity among government agencies and among government employees. All right, so this, of course, creates enormous risk and vulnerability to corruption. And so the question is, how do you prevent conflicts of interest or corruption in this setting? How do you prevent the government contracting process from being corrupted through personal conflicts of interest? All right, so let me just acknowledge there are several different approaches to dealing with personal conflicts of interest. And one approach to dealing with the personal conflicts of interest of contractor personnel is to impose on them the same standards that you apply to government employees. So whatever statutes that you, like a financial conflict of interest statute, or other regulations for that matter, in implementing the statute that apply to government employees, apply those to the folks who are the individuals who are part of staff augmentation contracts or personal service contracts. That's one approach. And in fact, up until 1962, the federal government actually took that approach, at least with regard to the criminal conflict of interest statute. It was in a different part of the criminal code, but up until 1962, the federal government's criminal conflict of interest statute applied not just to government employees, but to agents for the government. And that language reached contractor personnel, people who were not government employees. But in 1962, under the Kennedy administration, the government undertook a sort of a massive reorganization of its ethics standards that existed in the criminal code. And when it revised its conflict of interest rule, it revised it in such a way that it no longer reached agents of the government. And so the various criminal ethics standards that right now are in 18 U.S.C. 201 on bribery and illegal gratuities, up for like the next 20 or so sections. Almost none of them apply to contractor personnel. The bribery statute actually does apply to contractor personnel. It applies to people who act on behalf of the government. But the other ones, including conflict of interest, only reaches government employees. Okay, so that's one approach, is to have the same standards for government employees and contractor personnel. Another approach, just don't regulate the conflicts of interest of contractor personnel at all. And that actually, if you take a look at the 2000 ABA Model Procurement Code for state and local governments, that's what you find. You find nada, nothing, zilch, null on regulating the conflicts of interest of contractor personnel who are involved in the procurement process. Some good stuff there on regulating government employees, but nothing on contractor personnel. And then the third approach is the approach that the federal government took starting, in various ways. Maybe about 12 years or so ago, the federal government adopted a new procurement rule to address personal conflicts of interest of contractor personnel.
Possibly the other.
And I'll just say that this provision, again, it was under consideration for a number of years, was extremely controversial. But here's what it prohibited. It defined a personal conflict of interest as a situation in which a covered employee, someone working for a contractor, has a financial interest, a personal activity, or a relationship that could impair the employee's ability to act impartially and in the best interest of the federal government when performing under the contract. Okay, so that's a perfectly good, as an ethicist, I would say that's a fine definition of a conflict of interest. You have something of, financial interest, personal activity, or some relationship that could impair your ability to act on behalf of your principal, the government. All right. What this regulation, this PCI regulation on the federal government, imposes on contractors the obligation to have procedures in place to screen its covered employees for potential conflicts, to obtain information from those employees about potential interests, financial interests, and prevent the employees from participating on contracts, performing on contracts where the contractor has identified a PCI. So, how I was talking about there's this infrastructure in the federal government for dealing with federal employees' conflicts of interest and reviewing those financial disclosure statements. What this regulation kind of does, or attempts to do, is impose on at least certain government contractors this obligation to have some kind of infrastructure, ethics infrastructure, checking for conflicts regarding its from its own employees. The contractors are required to prevent employees with conflicts from participating and to prohibit the use of non-public information. Let me just flag that. That's a really big part of the risk involved with personal conflicts of interest of contractor personnel. Not just that they will personally benefit financially, but they may be able to exploit confidential information for themselves or someone else, share it. So restricting the use or disclosure of non-public information is also a key part of this regulatory regime. All right, and then the PCI, the Personal Conflict of Interest Regulation adopted by the federal government about 12 years ago, also requires contractors to discipline employees who fail to comply with their policy and report to a contracting officer any violations. Okay. I heard a little bit of laughter there, which I won't take personally, but I think instead is really aimed at perhaps the likelihood of being able to rely on contractors to report to contracting officers these conflicts. For one thing, I would posit, it's a little cynical, but I would posit that the route to advancement within a government contractor is not to be engaged in that function of monitoring the personal conflicts of interest of employees. Right? It's sort of like an anti-profit. It's for integrity purposes, but it may come with it certain consequences. Like imagine that Dennis Blair situation. Imagine being the ethics officer in that company and advising the head of the company that no, he can't advise the government on the F-22 contract because he has this interest in the subcontractor. I'm just suggesting that there are disincentives within organizations to engaging in that kind of enforcement or advice. Okay, so I've talked about what this regulation requires. Now let me tell you how narrow it is in scope. So it doesn't apply to all government contracts. It doesn't apply to all service contracts or all advisory contracts. It applies only to contracts that involve an acquisition function closely associated with inherently governmental functions. We come back to your phrase. So it only applies to functions, acquisition-related functions closely associated with inherently governmental functions. And then explains that this means, or at least it includes, planning an acquisition, developing or approving contractual documents, evaluating contract proposals, determining whether contract costs are reasonable. Would this regulation, as I've described it, the federal regulation, adopted about 10 years ago, would it even reach the Dennis Blair situation? Maybe. Maybe it would fall into this category of that Dennis Blair was involved in determining whether contract costs are reasonable, because reasonableness presumably has to do more generally with, if you're making a recommendation to the government on whether to extend the contract, presumably that would involve assessing whether the costs are reasonable. But I guess I want to flag how narrow the federal government's approach, in my view, has been. And I also want to, again, flag how friggin' controversial this was when the government attempted to, and eventually did, adopt it. Okay, so I guess I also want to say that the government can, in theory, impose ethics standards on contractor personnel directly. It can do so sort of indirectly, as some of you actually have alluded to in your states, by the government including in contracts themselves clauses that require the contractor to, check for and prevent personal conflicts of interest. But again, what I want to underscore is that most government contractors are not going to already have existing within them the kind of ethics infrastructure that the federal agencies have for decades to enforce federal, personal conflict of interest standards. And unlike the situation with organizational conflicts, such as when a contractor is asked to, evaluate its own work, or is asked to, or seeks and is awarded a contract that follows on from its earlier recommendations to an agency, it's not clear that competing contractors will actually have access to information about personal conflicts of interest. Correct me if I'm wrong, but I think competing contractors are more likely to know about a competitor's organizational conflicts of interest than a competitor's employees' personal conflicts of interest. And I just want to here acknowledge that the law on organizational conflicts of interest, much of it developed out of the bid protest world, at least on the federal level, that a company would be awarded a contract, a competing company that lost would lodge a protest, and there'd be an adjudication, an analysis of whether or not the contract was improperly awarded in light of an organizational conflict of interest. Those standards later were, in a sense, codified in regulation. But I have less confidence that competing contractors will just even be in a position to know about personal conflicts of interest. Yes?
I wonder, so if I'm Dennis Blair's attorney, right, in-house counsel.
Oh, so the company attorney.
Right. I don't have any incentive to say, this is illegal for you to do this, because there's no rule in place for me to say that. And at that point, isn't Dennis going to say to me, well, that's a business decision, get out of my office?
Okay, so when this happened in 2006, there was no rule dealing with personal conflicts of interest. Arguably, that is not the case now, right? If this situation arises now, again, depending on how narrowly you construe the federal rule. But I think that what you're raising, right, is, I think, this question of what are the incentives for these individuals in these companies to actually operationalize these standards, and can we rely on them? Now, that issue, really great issue, right, goes way beyond, right, is an issue like outside of the procurement context, obviously, outside of and I will say that there are things that governments can do to kind of change the stakes, to make it more likely that an insider will use whatever leverage they have internally to ensure that a contractor will comply with the law. And one of the key, in my view, one of the key ways that the federal government has done that, has empowered insiders to, operationalize, to make real the legal standards that apply to their companies, is by creating financial incentives for those insiders. And here I'm talking specifically about something like the False Claims Act. And if you're in certainly the federal procurement world for any time at all, you'll become familiar with the federal False Claims Act. But I think a fair number of states also have their own False Claims Act, which provide financial incentives to come forward and to act on, when you know about a false claim to the government for payment, to come forward as though you were acting on behalf of the government and filing a lawsuit against the company that has filed the false claim for payment. And so this actually comes into play on the personal conflict of interest front, as well as the organizational conflicts of interest front. So here's the connection I want to draw. The theory, right, is that when the government sends out its requests for proposal and eventually contracts for an objective analysis of whether to extend a contract, it is asking for objectivity, professional judgment, untainted by conflicts of interest, organizational or personal, okay? And if that's all part of that contract, but the company hasn't actually complied with those provisions and then makes a claim for payment under the contract, the theory goes under the False Claims Act, then an individual can sue on behalf of the, in this case, federal government, as a qui tam relator, and sue the company seeking an adjudication that company, in essence, defrauded the government by doing the assessment, but tainted by a conflict, okay? So there are, not a huge number, but there are some False Claims Act cases where that's what the critical issue is whether there was a personal or an organizational conflict of interest. And that, I would say, now the False Claims Act, of course, was created by Congress in 1863 in the middle of the Civil War. I don't know that the Congress in 1863 had sort of these organizational and whistleblower concerns exactly in mind. Nonetheless, I would argue that financial incentive statutes like the False Claims Act or Dodd-Frank, providing a different whistleblower financial incentive through the SEC, these, in my view, are some of the most effective ways to sort of operationalize good ethics within organizations, to address or counteract the disincentive that I think that you were alluding to. Did you have your hand up? No? Okay. All right. So let me say that, well, it sounds like, from what I can tell, most, and I think this is the case, most states do not actually have a statute or a regulation. There are a few exceptions, but most states don't have a specific statute or regulation addressing personal conflicts of interest of contractor personnel. If that is the case, if your state doesn't already have a statute or regulation addressing personal conflicts of interest, can you nonetheless impose personal conflict of interest standards on contractor personnel without a pre-existing authorization from a statute or a regulation? There was someone, yes, go ahead.
I'm not convinced we can do it effectively for reasons that you've already walked through, but we have tried around the margins. One example is we require every evaluator to sign a conflict of interest statement.
Every individual evaluator.
Every individual evaluator.
Whether they're an employee of the government or employee of an outside group.
Correct. And it is not that unusual so when we set up the lottery, 3 of the evaluators were administrators of lotteries in other states because they brought the expertise we didn't have, and we made them sign those conflict of interest. Had they been private, corporate, they'd also signed. The only other thing we've tried like that is when we first started OCI, we put in an OCI clause with no regulation, no statutory support for it, but it suffers from the same underlying flaw. There's no incentive to comply, and no one else knows about it.
Other states? Nothing? Yeah? Well, let me just tell you a little bit about the federal experience. So before the Federal Acquisition Regulatory Council adopted this government-wide personal conflict of interest standard about 12 years ago, a handful of federal agencies had addressed personal conflicts of interest. Some of them had actually adopted their own regulations, maybe like 6 or 7. But apart from that, even before a regulation, some agencies had addressed personal conflicts of interest by imposing standards through contract clauses. And one example is actually a U.S. Agency for International Development. There had been this scandal, I think in the early 1990s, regarding USAID having awarded a contract to Harvard University or some research group at Harvard University, and it turns out that the folks who were performing this contract, dealing with, providing advisory services to like the Russian government on markets, they had their own personal conflicts. They were investing in Russia. And there was nothing in the contract initially to prohibit that. And of course, they were contractor personnel, so they weren't reached by the federal statute applying to government employees. And after that, USAID started imposing on its contractors through a clause in the contract standards for their own employees' personal conflicts of interest. The last thing I'll say is this issue of personal conflicts of interest is not, and for government contractor personnel, is in no way limited to the procurement space. And one of the areas where it arose, I believe, in the news over the last number of years had to do with the Food and Drug Administration contracting with McKinsey consulting firm on a number of different things related to its regulation, to the regulation of opioids. At the same time that McKinsey and some of those very individuals, McKinsey employees, were advising Purdue Pharmaceutical and other opioid manufacturers and distributors. And so the stakes aren't just financial, right? The stakes that can be involved in these personal conflicts of interest of contractor personnel when the government outsources, brings in contractors to provide it with advisory services or assess one thing or another, the stakes, frankly, can be higher than just, millions or billions of dollars. Lives can be on the line. So on that really grim note, I'm going to stop. I think my time is just about up. So I'm going to stop because I don't want to be between you and lunch. So that's it. Thank you.